Welcome back to Legal English. In today's lesson, we're focusing on something every lawyer does: explaining legal letters and emails to clients. Whether you're drafting a warning letter, replying to opposing counsel, or helping a client understand a formal demand, your words need to be clear, respectful, and precise. Today, we'll go over how to handle legal correspondence in professional English so your clients trust your communication and your message is legally sound. Let's get started. Here's what we'll cover in this lesson. First, we'll work on tone, how to sound formal and professional in legal emails and letters. Next, we'll learn the difference between requests and demands. This is crucial when explaining legal documents to clients. Then we'll practice indirect speech so you can explain what a letter says without quoting it word for word. And finally, we'll look at conditional sentences, helpful for giving legal advice, warnings, and explaining possible outcomes. Let's begin with tone and structure. When you hear the words legal email or legal letter, what comes to mind? Maybe you think of formal language, the kind that sounds official and professional. Perhaps you imagine important notices like deadlines, legal demands, or responses to clients. You might also think about tone, how legal communication needs to be clear, respectful, but also with authority when necessary. Here are some key ideas we associate with legal writing: formal language, official notices, professional responses, important deadlines, serious consequences, and clear communication. Now, let's go through each of these key words. A legal email should always sound, I believe it should sound professional and clear. You want to be taken seriously, but also understood easily. One thing that makes a legal letter is, for me, its purpose and consequences. Legal correspondence often involves rights, obligations, or important decisions that have real-world impact. The biggest difference between a legal email and a casual one is the stakes. In legal communication, clarity isn't just nice to have, it's essential. Misunderstandings can have serious consequences. What do you think? Do these ideas match your experience? Well, let's explore the world of legal correspondence. Let's start with formal greeting. A formal greeting is a respectful way to open a letter or email. In legal correspondence, how you open your email or letter sets the tone for everything that follows. A formal greeting shows respect and professionalism from the very first line. For example, "Dear Miss Johnson, I'm writing to confirm our meeting," not, "Hey, what's up, Katie? How are you?" So you want to keep it formal. It sounds much more formal than just saying hi or hello. In legal writing, we typically use "dear" followed by the person's title and last name, or good morning, good afternoon, or good evening. "Dear sir" or "dear madam." It's still acceptable, though nowadays lawyers prefer "to whom it may concern," or even researching to find the specific person's name. The key: always err on the side of being too formal rather than too casual in legal communication. Next, let's talk about legal tone. Legal tone is the style of writing that is clear, respectful, and appropriate for legal matters. Legal tone isn't about sounding intimidating or using complicated words just to sound smart. It's about clear, respectful, and appropriate for the seriousness of legal matters. "We respectfully request your response within 10 business days." This sentence has the right legal tone. It's polite, but firm, clear about what's needed, and gives a specific time frame. Compare that to, "Please get back to me soon." That's too casual and too vague for legal correspondence. The legal tone strikes a balance, professional enough to be taken seriously, but clear enough to be understood by everyone involved. Now, let's look at demand. A demand is a strong request that often includes legal consequences if not followed. In legal writing, a demand is more than just asking nicely. It's a formal request that carries weight. Demands often come with consequences if the request isn't fulfilled. For example, we demand payment of the outstanding amount within 30 days, or we will pursue legal action. See how this isn't just, please pay us. It's clear about what happens if the person doesn't comply. Demands are common in legal letters because they establish clear expectations and consequences. They're direct, but they follow legal procedures for giving someone notice before taking further action. When you see the word demand in legal correspondence, pay attention. It usually means the situation is serious and time sensitive. Let's talk about clarification. Clarification is a request to make something more understandable. In legal matters, misunderstandings can be expensive and time consuming. So asking for clarification is not just helpful, it's smart. A clarification is a polite way to say, I don't understand this part. Please explain it better. We would appreciate clarification on the terms mentioned in paragraph 3. This is much better than just saying, I'm confused or this doesn't make sense. Notice how the request is specific. It points to exactly what needs to be clarified, rather than asking someone to explain everything all over again. In legal correspondence, this shows you're paying attention to details and want to make sure everyone is on the same page. Finally, let's discuss deadline. A deadline is a specific date or time by which something must be completed or submitted. In legal work, timing is everything. A deadline isn't just a suggestion, it's a firm date that has real consequences if missed. For example, please submit all required documents by Friday, March 15th at 5 p.m. Notice how specific this is. Not just by Friday, but Friday, March 15th at 5 p.m. In legal correspondence, vague deadlines cause problems. Saying as soon as possible or by end of the week leaves too much room for misunderstanding. Good legal deadlines are specific, realistic, and clearly communicated. They protect everyone involved by making expectations crystal clear. Let's move on to the word request. A request is a polite or formal way to ask something in legal correspondence. In legal writing, we don't just demand things, we make requests. This shows professionalism and respect, even sometimes when we're asking for something we're legally entitled to. For example, we respectfully request that you provide the documents by Friday, March 15th. Notice how this sounds much more professional than saying, give us the documents by Friday. The word request immediately signals that this is formal, professional communication. Common phrases you'll see include we request, I respectfully request, or this letter serves as a formal request. Remember, even when you have the legal right to demand something, framing it as a request maintains professional relationships and often gets better results. Next, we have without prejudice. This is a crucial legal phrase. Without prejudice means that the communication cannot be used against you later in court or legal proceedings. This phrase protects parties when they're trying to negotiate or settle disputes. It's like a legal safety net. For example, this settlement offer is made without prejudice to our client's position in the litigation. What this means is we're making this offer to try to resolve things. But if negotiations fail, you can't use this offer against us in court to say we admitted weakness. You'll often see this in settlement negotiations, where parties want to explore resolution without damaging their legal position. It encourages honest communication because both sides know the conversation is protected. Think of it as creating a safe space for legal negotiations. Our next word is response. A response is simply a reply to a legal letter, email, or notice. But timing is everything in legal communication. In legal correspondence, responses often have deadlines, and missing these deadlines can have serious consequences. For example, your response to our demand letter must be received within 10 business days. Notice how this clearly states what's expected and when. Legal responses aren't just casual replies, they're formal communications that often require specific information or actions. Common types of responses include responding to a demand letter, replying to a settlement offer, or answering a formal notice. Each type has its own requirements and timeframes. Key tip: always respond within the specified timeframe, even if it's just to acknowledge receipt and request more time. Silence in legal matters is rarely golden. Now, let's discuss legal consequence. A legal consequence is a result or penalty that may happen if the conditions in the letter are not met. This is where legal letters get their power. They clearly state what will happen if the recipient doesn't take the requested action. For example, failure to comply with this notice may result in legal consequences, including court action. Legal consequences can range from financial penalties to court proceedings to loss of rights. The key is that they must be clearly stated and legally enforceable. You'll often see phrases like failure to respond may result in, or non-compliance will lead to, or legal action may be taken. Important to remember, legal consequences should never be empty threats. They should only include actions that can and will be taken if necessary. This maintains credibility and legal integrity. Finally, we have client instruction. Client instruction refers to the formal direction given by a client to their lawyer about how to handle their case. This is fundamental to the lawyer client relationship. Lawyers act on behalf of their clients based on these instructions. For example, based on your client instructions, we will proceed with the settlement negotiations. Client instructions can cover strategy decisions, settlement amounts, which actions to take, or how to respond to the other party. They're usually documented in writing to ensure clarity. You might see phrases like, we have instructions from our client to, or our client has instructed us to, or based on client instructions. Remember, lawyers have a duty to follow lawful client instructions, but they also have a duty to advise clients when instructions might not be in their best interest. It's a balance of advocacy and professional responsibility. Picture this: a law firm receives a complaint from a client about unpaid invoices. The lawyer sits down to write a letter to the debtor. She starts by saying, "Hey there," but then stops and deletes it. Instead, she writes, "Dear Mr. Thompson," because she knows this sets the right professional standard from the very first line. What's the term for this respectful way to open legal correspondence? Exactly. It's a formal greeting, a respectful way to open a letter or email that sets a professional tone. Next story. A client walks into a lawyer's office, furious about a contract dispute. I want you to threaten them, make them scared, the client shouts. The lawyer calmly explains, I understand your frustration, but I need clear directions on how you want me to proceed legally. Do you want to pursue mediation first or go straight to litigation? What do we call these formal directions the client gives to the lawyer? Exactly. Client instruction. It's the formal direction given by a client to a lawyer about how to handle their case. Next story. Imagine a tenant receives a letter from their landlord that says, you must fix the noise complaints from your neighbors immediately, or we will begin eviction proceedings. The letter clearly states what will happen if the tenant doesn't comply. What do we call this potential result that's outlined in the letter? Legal consequence, which is a result or penalty that may happen if conditions in the letter are not met. Now, let's imagine that two companies are in a heated argument, over a failed business deal. Before going to court, one company's lawyer writes, we are willing to discuss a settlement of $50,000 to resolve this matter. And this offer is made to our client's position. Should litigation proceed? The lawyer uses a special legal phrase to protect their negotiating position. What phrase protects them from having this offer used against them later? Without prejudice. Without prejudice is a legal phrase that allows communication without affecting legal rights in future proceedings. Or how about this story? A law firm sends a letter to a company about copyright infringement. The letter states, you have violated our client's trademark rights and must cease all unauthorized use immediately. This isn't a polite request. It's a firm statement of what must be done. What do we call this forceful type of legal communication that requires immediate action? Demand. A demand is a firm statement requiring immediate action or compliance, often used when legal rights have been violated. So today we're learning about indirect speech in legal communication. And this is absolutely essential for every legal professional. What is indirect speech? Well, indirect speech, also called reported speech, is how we professionally explain or report what someone else said, wrote, or requested. In legal work, you're always doing this, briefing clients about what the other party wrote, updating your supervisor or boss about phone conversations, or summarizing correspondence in case files. Why do we need this? Because in legal communication, you rarely just read someone else's words verbatim. Instead, you report them professionally. It's the difference between sounding like you're just repeating gossip versus presenting information like a trained legal professional. The basic structure is simple. Subject plus reporting verb plus connecting word plus the message. The subject is who said it. The lawyer, the client, the judge. The reporting verb tells us how they communicated. For example, said, wrote, asked, demanded, explained. The connecting word links it together. That for statements, if for yes no questions, and the message is what they actually communicated. Let's see this in action. If someone writes, you must pay within 10 days, you don't just repeat that exact phrase, you report it. The lawyer said that the client must pay within 10 days. Notice what happened? We added the lawyer said that at the beginning, and we clarified who you refers to by saying the client. For questions, if someone asks, "Can you clarify clause 5?" you report it as the client asked if we could clarify clause 5. We use asked if for yes or no questions. For statements about the future, we will terminate the agreement becomes the company stated that they would terminate the agreement. Notice how will changed to would? This is called backshifting, and it's normal in reported speech. Here's why this matters in legal work. Every day, you'll be reporting what others have said or written, whether you're updating a client about correspondence, briefing your boss about a phone call, or writing a case summary. Indirect speech keeps your communication professional, clear, and accurate. Think of yourself as a professional messenger. You're not just repeating words, you're professionally conveying important legal information. Today, we're focusing on conditionals in legal writing, and this is one of the most powerful grammar tools in legal communication. What are conditionals and why do we use them? Conditionals are if then statements that explain what will happen under certain circumstances. In legal writing, they're absolutely essential because law is all about consequences. We need to clearly state if this happens, then that will follow. Think about it. Legal letters often need to warn people about consequences, explain obligations, or outline what happens next. Conditionals give us the perfect structure to do this professionally and clearly. The basic legal structure is this: if plus present simple, will plus verb. This creates a clear cause and effect relationship that leaves no room for confusion. Let's break down a typical example. If you do not respond within 7 days, we will initiate legal action. So the condition, if you do not respond within 7 days, this is what might happen. The consequence, we will initiate legal action. And this is the result if the condition occurs. Notice how clear and direct this is. There's no ambiguity about what will happen. We have other legal variations too. Unless payment is received, the contract will be terminated. Here, unless means if not. It's another way to express the same conditional relationship. Should you fail to comply, penalties may apply. This uses should, which is more formal and often appears in official legal documents. It has the same meaning as if, but sounds more authoritative. Why these phrases work so well in legal writing? If you fail to directly addresses non-compliance. Unless you provide emphasizes what's required in the event that you do not. Very formal, often used in contracts. Should you refuse to implies the person has a choice, but there will be consequences. The power of conditionals in legal communication, they create accountability. When you write, if you do not pay by Friday, we will file a lawsuit, you're not making empty threats. You're clearly outlining a logical sequence of events. The recipient knows exactly what they need to do and what will happen if they don't. This grammar structure protects both parties. It's clear, it's fair, and it's enforceable. That's why conditionals are the backbone of effective legal writing. Now, as always, my favorite part, idioms. Let's start with the idiom on notice. This one is common in legal writing, especially in letters and formal warnings. When someone is on notice, they've been officially informed that something is wrong or that action might be taken. Imagine a landlord sends a letter to a tenant saying, "This is your third noise complaint. you are now on notice. That means no more excuses. If they continue, consequences could follow. In legal terms, this is important because it creates a record. Once you put someone on notice, you set the stage for escalation. And legally, you've protected your right to act. Open the door to liability. This is one of my favorite and most used idioms for client conversations because it sounds visual and serious. Open the door to liability means you're doing something or failing to do something that might create legal risk. For example, imagine your client keeps hiring independent contractors without clear contracts. You could say, if we don't address this, it might open the door to liability, especially if one of them claims employment rights later. It's a great way to warn without scaring. You're not saying something is already illegal, just that the door is open and someone might walk through it. Play hardball comes from baseball, but it's all over legal English, especially when we talk about negotiation style. If a client says, I want to play hardball, what they mean is be tough, take a firm stance, don't compromise. This doesn't usually go in a formal letter, but it's perfect when you're talking with your client about how to respond. For example, should we give them a discount? The client says, no, let's play hardball. Full payment or we sue. So when you hear play hardball, think assertive, confident, no backing down. Now, put someone on notice. This is very similar to the one you heard before, but it's a bit more formal than on notice because it's about the action you take. To put someone on notice means you're the one sending the warning, officially and in writing. For example, say a company supplier keeps delivering late. You might write a letter says, we hereby put you on notice that continued delay will lead to contract termination. Now that's serious and it's legal. Putting someone on notice isn't just a phrase, it's a step in the process that often leads to legal claims or penalties if they don't correct their behavior. So, if you're writing a legal email or advising a client, use this phrase when you need to make it clear. We've warned them, and the next step might be legal action. Let's wrap things up. Today, we focused on a skill that every legal professional needs, explaining formal written communication to clients in a way that's clear, confident, and accurate. We looked at how to use formal tone in legal letters and emails, and how small changes in phrasing, like turning a demand into a polite request, can completely shift the tone. You also learned how to report legal language using indirect speech, something especially useful when summarizing a demand letter, warning, or client communication. And we ended by using conditional structures like if you don't respond, legal action may follow, to help you explain options, risks, and consequences in a way clients can understand. Now, take a moment to reflect. Which of these strategies will you use the next time you're writing or explaining in a legal letter? Do you feel more confident walking your client through what a letter says and what it really means? Thanks for joining me today, and I'll see you in the next lesson.